Thank you for BDI for inviting me to address you this session on redevelopment and conveyance. As all the board of directors of BDI giving me this opportunity, and I will be taking about 7 to 10 minutes. Very important 3 topics. The first thing is, let us understand the redevelopment started somewhere in 2000 in Mumbai, and at that time, as we are aware, that TDR concept started somewhere in 1994-95, and in Khar and other areas, especially Bandra, Khar, we could see that existing building, they used to erect pillars and then they used to construct additional floors. And existing members were getting the building repaired, and of course they were also getting some additional areas by way of balconies and other things. But over the period it was realized that those type of development cannot sustain. So the government said, if at all it has to be happening, it has to be complete redevelopment. That means demolish the existing building and construct the new building. And that is why 2000 onwards, the actual redevelopment started in Mumbai. And 2000 to 2009, approximately about 9 years, the government realized there are so many issues related to the redevelopment, that too especially in the selecting of the developer or the issues related to the transparency in entire process. So therefore government constituted a committee and government GR was issued as to how the housing society could process the redevelopment. That is commonly known as Direction under Section 79A of the MCS Act on the redevelopment, 3rd January 2009. Over the period of 10 years, I am just coming to the housing society's process. Then over a period of 10 years, it was realized that redevelopment circular further required certain amendment. Again a new committee was constituted, and in 2019, 4th July 2019, a new circular has been issued to go for redevelopment. With 51% members approval, a redevelopment is possible. Many challenges, many issues were raised. Whether the 3rd January 2009 or 4th July 2019 circular, whether they are compulsory, mandatory. Number of judgments of the Honorable High Court has said, these circulars are more of a directions or a directives. The moment it comes as a directives, that means it is more of a guideline. They are not mandatory. They are the procedural aspect. A procedure can be, modified to taking into account the situations of the society. So therefore, let me make it very clear, 4th July 2019 circular is not mandatory. There is not, I am saying, it is n number of judgments of Bombay High Court has said. So therefore, if it is not mandatory, whether the society should follow this procedure, I would recommend, yes, because this is issued under the directions of the government and it is more of a guideline, so the procedure should be followed. Now I am not getting into the intricacies of the circular. Now in this circular, as I said, more than 51% members give the consent for the redevelopment. This is possible. Redevelopment is possible. Then what happens to the another 49%? Naturally, if they don't adhere to the decisions of the general body, then the law will take its course. So therefore, yesterday you must have seen in the various WhatsApp group and social media that on 13th of April 2022, as latest as few days back, Honorable High Court, Justice J.S. Kulkarni has held in the one case, that is of Choice Developers versus Pantnagar Pearls Cooperative Housing Society Limited. What it has been held, that minority members does not have any status in the process of redevelopment. Once they become a member of the society, whatever is the decision taken in the common good of the society will be binding on all the members. So there were 3 people who were opposing the redevelopment for one or the other reasons. The Honorable High Court went to one further step, said that such minority members should be taken and made accountable and responsible. What was the issue in that? The developer, after investing crores of rupees, took the IOD. Out of 30 members, 27 members vacated the building, and after vacating 27 members, referring to the arbitration or maybe going to the cooperative court or by any other claim. So that means the law will definitely, in a days to come, minority members will be made accountable and responsible. Yes. The next thing arises, what are the documentation that is required and what we should do. The major documentation is of course a development agreement, and followed by the development agreement there will be permanent alternative accommodation agreement. There were a lot of issues as to when this permanent alternative accommodation agreement has to be executed. Basically, once the IOD comes, plans are approved, and at the time of before vacating the premises, I would suggest that permanent alternative accommodation agreement should be registered. Now the question arises about the stamp duty. Yes, the government is planning and working on making the stamp duty only 100 rupees for the purpose of permanent alternative accommodation agreement. Because of the BDI initiatives about 4 years back, the government IGR, in fact I was also involved in that process and I had met that time IGR also, and in the discussion process he also said section 4 of the Maharashtra Stamp Act does say that if it is a supplementary agreement to the main document, it has to be on 100 rupees. However, the members of the society, they are not the parties to the development agreement, and therefore it becomes difficult to implement section 4 of the Bombay Stamp Act or Maharashtra Stamp Act. Therefore, it was directed by the IGR that if a society is the owner and the members are the conferring party and the developer is made as the, of course, receiver of the benefit, receiving the development right, in that case, permanent alternative accommodation agreement will be made on 100 rupees. So that means if you are making a member as a conferring party, your permanent alternative accommodation will be on 100 rupees stamp paper only. Now there will be 3 or 4 people who are not signing the such development agreement. In that case, they may have to pay additional duty on the construction cost which is given to them. Now whatever is the existing area plus free area, entire thing will be free of cost. Now of course GST is there, one of the aspect which Jayesh Bhai will take it little later. I will not touch upon it. It is one of the grey area as to whether a rehab portion will be liable for GST or not. The existing members, whether the GST is applicable or not, I will leave it to the expert little later. Now income tax, absolutely there is no income tax of whatsoever. Whether you are getting a hardship allowance in the form of corpus or the permanent alternative transitory accommodation, temporary rent that you are receiving, or additional free area that you are going to receive, on that there is no income tax of whatsoever. So this has been held by a number of High Court judgments. Now, I will move further. I think redevelopment has now settled. Please don't get into further intricacies. There are various people in a housing society, they listen to half of the stories and they demand the additional areas. I'll give you a few examples wherein the government, in order to make the redevelopment successful, has allowed the fungible FSI 35% of the existing built up area as a free of premium. Of course, there are requirements. The number of units, the members, they have to give in the original registration record that these are the people who are there as a members. Secondly, you have to give the approved plan, or at least your structure was in existence before certain years, that you need to inform to the government. If you don't give this type of proof and you do not have the OC approved plan and other things, naturally you may not get the fungible FSI. This should be known to the people. Those fungible FSI, you will have to pay 50% of the ready reckoner value as the premium. So then the project becomes unviable. What happens with the housing society is, the neighboring society has given 40% extra area, whereas my society, they are giving 20% extra area. How come it is possible? That means another 20% is taken over by the managing committee in hands and gloves with the developers. It is not so. What happens is, one has to look at the viability of the project. So the viability of the different project depends upon various aspects. One of them is the road width. Second is what is the existing FSI that you have consumed. Many times the existing societies have consumed more than 30 to 40% additional area. How this is possible? Because of the earlier setback areas or whatever you have surrendered. Nearly 40% extra FSI has been consumed by the existing members. So therefore it becomes very difficult. Second thing, many people are saying that 33(7)(b), there is one provision where 10 square meter is given to the existing members free of FSI, or rather free of premium. That is additional FSI. People are thinking that means 35% is one, which is free of FSI or premium, that is a fungible FSI. Another 10 square meter, which means 100 square feet approximately. That also should be given to us. That means they are expecting that 100 square foot plus 35%. Please don't do that. And because of that, many times the differences happens in the housing society. Please appoint an architect or a project management consultant, get the feasibility done, understand your viability of the project, and thereafter you move. Now there are various issues that we need to give the public advertisement for inviting the either PMC or the developer. Absolutely not required. The GR does not say about it. If people are by majority selecting a developer even by an invitation, that is more than enough. With this, I think redevelopment, I am concluding with the last only one line, that whether the self-development is possible. Yes, it is possible if the people are ready to contribute. Now, the Mumbai Bank, which wanted to give funding for the self-development, RBI has stopped them. Now the private banks and the cooperative banks, other banks are not interested in giving housing loan or the project loan for a self-development to housing society. The main reason being, none of the members take the onerous. They don't take the responsibility. So the chairman secretary may resign any time and it may create a problem. Secondly, the managing committee does not have the required experience in executing the project. These are the reasons. Therefore, self-development is not taking the shape. However, that is also one of the modalities which is available to the smaller societies if they think that yes, they can build their own house. It is not that easy. Now let me come to the second issue which was happening in the case of redevelopment when we were talking about in the year 2000. That was especially related to the conveyance. Unless until you have a conveyance of the land and building and the property card is in the name of the society, you are not in a position to go for redevelopment, get the plan approved. And therefore, the government has come out with the amendment to the Maharashtra Ownership Flat Act. That is nothing but deemed conveyance. What is deemed conveyance? Deemed conveyance is nothing but an amendment in the MCS Act, MCS in the Maharashtra Ownership Flat Act, where it says, if a developer has given you the flat and the housing society has been formed, as per section 11 of MOFA, the developer is supposed to convey the land and building to you within 4 months of the formation of the society. And if this is not done, as per the provisions of the law, it is deemed to have been done. That means it has been decided by the law that you are the owner of the land, owner of the building. But will this deemed provision help the society to get the conveyance deed registered? Will this deemed provision help them to get the property card? The answer is no. Then what should be done? Therefore, the law has provided a competent authority. Who is the competent authority? District Deputy Registrar has been designated as a competent authority, where the society need to approach the District Deputy Registrar, make an application with all the credentials of the society, members' credentials and the approved plan and your land record like Satbara or property card, and then make an application on 2,000 rupees court fee. By making this application and demanding the conveyance from the District Deputy Registrar, by conducting the hearing within 6 months, District Deputy Registrar grants you the conveyance. He executes the conveyance deed. He steps into the shoes of the earlier developer. He steps into the shoes of the old promoter, developer, landowner, and he executes the conveyance deed in your name. This way, your conveyance deed gets registered by paying a appropriate stamp duty, Now let me tell you two things, very important for the people who have come today, which we are working for the last 6 months, and I am sure in next 2 months this will come in the limelight and it will be notified. What are the two things? One is amnesty scheme for the old building where they do not have the occupation certificate, where the people are occupying. In the year 2004 there was a amnesty scheme for occupation certificate. For some or the other reason that amnesty scheme was not successful, but this time with the interaction with number of ministers and of course with the UD and of course on amnesty scheme for the stamp duty, the people who did not pay the stamp duty on their resale agreement or the earlier agreement, now the amnesty scheme for the stamp duty is coming. It will most probably come on 1st June 2022. So the process is in line. So therefore the societies who are looking for the deemed conveyance or a conveyance and the people who want to get their agreement regularized, please look at this amnesty scheme, and this will be much easier amnesty scheme, and let me tell you, please take the benefit of that. Otherwise the penalty is 4 times. 4 times of the stamp duty will be levied as a penalty. If the stamp duty is 1 lakh, 4 lakh will be your penalty. So therefore take care of that. So with this I am saying, please take the benefit of deemed conveyance. And the second question arises, whether this deemed conveyance is applicable for the RERA registered project. The answer is absolutely yes. Even for a RERA registered project, this is applicable. The last topic which is given to me is about the RERA in relation to housing societies and the stalled project. Yes, RERA has been effective in Maharashtra from 1st May 2017. RERA is protecting the interest of the flat buyer. Now, the question arises, the projects which were stalled, of course they are registered with RERA, whether the earlier flat owners get protection. The answer is yes. The Supreme Court in the case of New Tech Promoters and Developers Private Limited versus UP State has already said that the RERA has a retroactive effect. Of course, Bombay High Court also on 6th December 2017 in the case of Neel Kamal Realtors versus Union of India also has held that the ongoing projects which are registered with RERA, those started about 10 years back, will have the implication on RERA, and therefore it is retroactive. What are the benefits which are given to the flat buyer? Very simple. If the projects are delayed beyond what has been stated in the agreement of the date of possession, you are entitled to get the interest for the delayed possession about SBI's MLRC, marginal lending cost rate, plus 2%. That is from the date of possession mentioned in the agreement till you get the possession with OC. The second option, the buyer will be able to exit from the scheme. Even if they exit from the scheme, in that case also they will get the entire investment which they have done plus interest at the rate of SBI plus 2%. So this is a major benefit which is given to the flat buyer. Other than that, of course, the plans cannot be amended without 2/3 consent, and the various other aspects are there. The leakage and the seepage for 5 years, the developer need to take care. And most important is the money which is received from the allottees, that is a flat purchaser, need to be put it in a separate account called RERA designated account. And to withdraw that money, 70% has to be put in the RERA designated account. To withdraw that money, certificate from 3 professionals. One is the architect regarding percentage of completion of the work. Second is regarding the structure completion by the engineer. And the third is about the financials from the accounts, how much money has been spent on that project from the chartered accountant. So the chartered accountant will give a certificate as to how much money the developer has already invested towards the land cost and building cost on that project. To that extent, he will be allowed to withdraw from the RERA designated account. That means there is complete financial discipline. And this financial discipline is enforced through these 3 professions. Now disputes are concerned. However, they are indirectly protected. How they are indirectly protected? They are indirectly protected because the money that is coming from the allottees are put in a RERA desk account. The entire project gets registered. The execution of the project is monitored and administered and getting reported through the RERA, and the RERA will monitor the entire project, and the allottees will be more alert and see that the projects properly gets implemented. So therefore, there is an indirect control on that project through the RERA, through the new purchaser. However, the existing purchaser will not be able to go and take the redressal before the RERA. The question arises, then what is the recourse available to the existing flat purchaser or the existing flat owner or the housing society? Yes, they may invoke the arbitration clause, they may go to civil court, they may go to high court, and they can do other things. Most importantly, the members also are entitled to go to the Consumer Protection Act. They can take the recourse under the Consumer Protection Act because the services which is given by the developer is nothing but a construction service, and therefore they are covered under the Consumer Protection Act, and there you can get the remedy. With this, last and most important is about the stalled project. Yes, there are more than 3,500 RERA registered projects have stalled. Now the projects are stalled for various reasons. Maybe the developer has expired. There may be litigation between the developer and the existing society members. There may be various fund problems. So many things are there. But what is the recourse? I would only say that in such cases, the existing society and the developer who has involved in that project need to sit together and sort out the differences and see that how the project can be taken forward, and permit such a developer to bring another investor, and without demanding further recourse, the existing members or the society should allow them to redevelop. That is the only thing I would say. Otherwise, the litigation does not have any limit. That can end up to Supreme Court, and it may take years together, and you will be out of the house without getting the rent or without getting the new. The last and most important, the many housing societies are taking a recourse of Vaidhi Akash judgment. And it is unfortunate. I am telling in the open statement, it is unfortunate. Some of the developers do promote the housing societies to take the recourse under this type of Vaidhi Akash judgment, which says if a developer has created any liability, the moment the society terminates the developer, the allottees who have paid crores of rupees to that promoter will have to go to that promoter only, and existing society by terminating them can appoint a new developer, and in the new way the redevelopment can start. It is not that easy as you and I sometimes. So therefore, whether it is a Vaidhi Akash, take away the benefit of the allottees who have put crores of rupees, the time which is already invested by the existing developers, and making the life of those allottees, existing members and the developer miserable. I would only say that unless until you sit across, because it is a joint venture between the existing society and the new developer, if there are any issues, please sit across the table and resolve the matter instead of taking it to the litigation mode. With this, thank you very much for giving me this opportunity, and you may have number of questions, but definitely we will take it later. Thank you.